And we're live.
Right.
Thank you everyone for joining us today. Today we're gonna have a panel with Ross Birkbeck from Casedo and Tony Guise from DisputesEfiling. Thank you for tuning in and joining us. So before we begin, could both of you give our audience a bit of background on your entrepreneurial journey to date and how you came to start your respective startups?
Okay. Well,
Tony, you go first.
barristers first, I was going to say, but I'm happy to go first.
You.
Okay, fine. How did we start? How did I start my entrepreneurial journey? Well, it started for me at an early age when I decided that I always preferred to be an owner rather than not an owner, whatever that might look like, and consequently, being a commercial litigation solicitor, one is very much, in my experience anyway, at the mercy of the market. This talk about trying to make, which has been going on for some time, legal markets much more competitive always struck me as rather odd. I found it one of the most competitive markets, the law, that I've ever known. And so I had to develop my own practice. And then I made the decision in 1991 to leave my hometown where I was practicing at Birmingham and move to London to try to further develop my practice. And so I brought very few clients with me and then had to start again a process of renewal and a process of challenge, if you like. And that's something that's characterized everything I've done. I've always tried to challenge myself and to see what more I can do than I have done before. And so I developed that practice within a city law firm. And then I felt that the time was right to set up my own firm, which I did in 2003 and ran that remarkably without a loss at any time until I decided to do something else. Which was in 2016, and that was to move into the legal tech sector with a product, which that we'll talk about in more detail later. But again, that was partly because I had been very actively involved with Lord Woolf and Rupert Jackson and Lord Neuberger for many years, trying to get effective IT into the civil justice system. And that was, if you like, what I did as a hobby rather than for a living. And so what I do now has grown out of that civil justice reform agenda. So this, I hope, gives you an idea about why I ended up where I am now.
Interesting. And Ross, how did you end up starting Casedo?
Well, my journey into the tech world, it came out of a personal need I have. So I have a previous life as a video editor, and I ran a post-production house, small, just a couple of us, doing post-production for film and television mostly in my prior life before law. And then when I converted to the law, I was used to using technology in a certain way and really having it integrated into the way I manage data and the way I manage my work. And I came to the law and I expected there to be a tool there for me that would allow me to continue working in an analogous way. I couldn't find it. I spent a long time looking for it. I assumed it must be there, and I looked and looked and looked. And eventually, I got bored of looking, and I started dreaming what I wanted. And eventually, I got bored of thinking about what I wanted, and started thinking about how to build what I wanted. And that led me down the line into putting together a team and raising some funds and building the actual tool itself. So for me, it's come out of, as it were, personal need, and it still is. I mean, my desire to push my product, my Casedo, to develop it further, comes primarily from the work I also do on the side as a lawyer. Who knows which is on the side anymore?
Nice. So the question I want to ask is then, because both of y'all started these startups at a time when you guys were at the heads of your careers. Tony, you were running your own company. You were running your own law firm. And Ross, you are, and well, you still are a head barrister, a head tax barrister. And the question I want to ask is that you must have faced some opposition when you started these companies. So why did you opt to start your company despite all the opposition? Like, what drove you to choose and say, yes, this is what I want to do. This is what I want to make. I want to make something, you know?
Do you want to start on that one, Ross?
I'm very, very touched to be called a head barrister. I'm far from it. I'm actually a rather junior barrister. And in fact, when I started the road in Casedo, I was pretty much still a student. I mean, it was during my pupillage that I started putting it together. So the final stage of my training. So it was probably an incredibly rash thing to do, and I think there have been times when I've had to keep it quiet in terms of sort of my bar work, and because both of these things need a lot of attention, and you can't be seen to be conflicted on that. So no, for me it was very much a case of it was something I personally felt driven to build and to make, and it came out of that. And obviously what I found is that I took on a lot more than I probably initially intended when I set about just trying to create a useful tool. And I'm now fully immersed in the sort of legal tech business and that market, and looking at what can be done with that. But it's in many ways accidental is probably my answer.
Yeah, well, from my perspective, it wasn't really accidental in the same way, because of the civil justice reform agenda that I've pursued up to that point for about 18 or 19 years. So it was, if you like, a progression. But there was and remains to a certain degree a lot of opposition to ADR. It's not necessarily overt, as the Lord Chief Justice said in a Bailey lecture of 2018. It's very often concealed behind clever arguments, or something rather more elegantly expressed by him than my attempt to parody him, or to paraphrase him rather. So the opposition was cultural. Lawyers don't like ADR necessarily, because it shortens the duration of a case. And of course, most are still paid by the hour, and the fewer hours that are spent, then the less one earns. And so I understand that instinct. The other thing that I decided to make my task, as it were, if not doubly then trebly difficult, was to argue that not only should there be much more ADR, but that should be conducted and managed not by the Zoom necessarily at the end, but the whole process should be online. And lawyers hate online because they like doing things the way they've always done them, from precedent to precedent. And change always troubles people, and it troubles lawyers very much so, because they like consistency, not efficiency necessarily. So that's kind of how what made me do it, because I just like, as I've tried to explain before, challenges. I'm about to say this one is probably the biggest one I've taken on.
Interesting. Sorry, we have a question from Ross, which is that from what we understand, Casedo's mission is to provide people with a tool that will make research, collation, and reference of documentation seamless. So could you talk more about who you aim to serve, and how do you see your demand for your product growing in the future?
Yeah, so and it's quite a very good description of Casedo. Actually, it's a tool to do a sort of the job that is at the centre of what lawyers do, which is reading documentary evidence, contracts, anything we're asked to read, figuring out what it's all about, and then sort of pulling out of that a story or an argument. So really, it's aimed primarily at myself and people who do what I do. I mean, that's our first audience is barristers who get sent instructions and have to figure stuff out, or doing legal research. But step wider, and obviously all litigating solicitors have that problem very acutely as well. So those are a core part of our target market. Step beyond litigating solicitors into general solicitors more broadly, conveyancers, transactional solicitors. They don't have the problem in exactly the same way, in the sense that they're not saying, oh, here's all the evidence and the papers that relate to my case, can you argue it? Are we going to win? What are our chances? There's more of the transactional and solicitors tend to, their paperwork tends to involve more, but they still have that problem of they've got to understand the documents in front of them. They've got to be able to read and move about them fluidly. They've got to be able to pull out the relevant facts and law out of that. So within the legal world, that's who we're targeting. Anybody who does that work, the core legal work of sitting down and reading and trying to understand their papers. But of course, students are probably the other people who have this problem every day. It's in the nature of what they do. They're being asked to, figure something out. Here's whether they start with lecture notes or textbooks, or whether they're told to go and trawl the internet or find their own research. Their job is to pull information together, process it through their brain, and spit out, an essay or something in the same way that I spit out an advice. So I think those probably are our key core markets for now. And what we've interestingly though found that increasingly we're getting people coming back to us saying, oh, there's a fantastic use case here. Board meetings is a very good one because it's easy to throw papers together for board meetings. We had someone suggesting the other day that GPs would use this for putting together medical records when they're asked to throw together medical records. There was some interest in that. So we're finding, who knows who will. It's designed to be a flexible tool, and we're seeing people take an interest in it just as that. But our core audience remains the people with this problem most acutely, which is me.
Might I just can I just at this point, Ross? Very interesting to hear you speak about that. And I suppose there are 2 points I'd like to make. The first one is I very much doubt any advice by you would be spat out, as it were, if I might say so. But ultimately, what you're trying to do and what I'm trying to do is has this theme running through it of drawing out efficiencies. And that, on the face of it, might trouble some lawyers who fear their workload being erased by efficiency. But in fact, I wonder if you agree with me that in fact what that does is free up time for lawyers to do less thumbing through lever arches, law reports, whatever, and spending more time thinking, which surely is the value add in the lawyer-client proposition. I don't know. How do you
exactly right. I think as a lawyer these days, you should be looking to take more cases on because you can deal with them more efficiently. Because go back even 30 years, you had to trunk into the Lincoln's Inn Library to find the law to figure out what your case was. Now it's a click of a button on Westlaw, whatever. You've got so much more available to you in terms of resources, both on the sort of the hard law side of it, but also on the procedural stuff. And I mean, my practice is almost entirely fixed fee. Which is quite rare at the bar, but I think probably plays into my desire for better tools to allow me to do work quicker. Because for me, literally, the quicker I can get the job done, the more free time I have. And there is a direct correlation between that because I'm not being paid to do things slowly. So yeah.
Yeah, that's the thing, isn't it? That point you've just made is exactly the value add proposition. It means if you can get through the work, produce a quality piece of advice quicker, then there's more space for either your personal time or more work.
Yeah, exactly.
I've just realized that, Tony, we haven't yet talked about DisputesEfiling. And I'm actually quite fascinated with the work that you do, actually, because what you do is that you integrate the entire litigation process together from start to finish on a convenient platform that caters to mediation and arbitration. So could you tell us more about it and set how your product is set in the context of legal justice reform?
Yes. So I'll explain what the platform does briefly, and then I'll try and set it in a context that explains how it came to be. So we call it the One platform internally anyway, and that's because it is what is called an end-to-end solution for managing alternative dispute resolution. And the reason it does that, although it can be used in court proceedings, civil court proceedings, is that I lost another tender, which was in 2014 to supply the e-filing solution for the roles building jurisdictions. I was in good company. There was my company and Thomson Reuters. They were the lucky ones in that situation. And I was then approached to develop this an arbitral platform to manage arbitrations for Andrew Ritchie QC, who developed personal injury claim arbitration service, the first arbitration service for personal injury and the first to be entirely online. And from there, we grew the product out so that now we have an entire solution for the whole of the litigation process, starting with, we have various modules, starting with pre-action. So we have a specific module for the parties to manage their pre-action activity. And then we have a convert function, so that if one can't settle it within the pre-action context and the parties agree to mediate or arbitrate or adjudicate or indeed to have a neutral evaluation, we have a convert function that transfers the data from that pre-action module automatically into the relevant module for whatever ADR process that the parties choose to do. And we have something called the virtual filing cabinet, which creates, unlike, for example, other collaborative platforms such as Dropbox, say, we have a virtual filing cabinet with, if you can imagine, the drawers in a filing cabinet, but they are structured. So, for example, for a personal injury claim, we have pre-action correspondence. We have letters of statements of claim, defence, reply, if any, witness statements, disclosure. Then disclosure is broken down into various categories, medical reports and a whole host of medical evidence by categories, though. So one can filter those categories to identify what you want to see, rather than starting off with an unstructured and sometimes perhaps incoherent PDF, for example, where you have to kind of struggle to find things. And so it fits in, it fits in, to my mind, with the very strong trend at the moment, both from judiciary and elsewhere, toward ADR. And there's no point having lots of ADR going on without that being managed online. The citizen will not expect it to be conducted by lever arch.
Yeah. And just in there, I mean, what I take away from that, Tony, is
I froze.
Sorry. I think Ross, your camera's not working. I'll just give it a while to come back.
I can see you. Hello.
Okay, we can hear you.
Just there you are.
Okay.
Yeah.
I'm sorry about that. I can see you guys. I was just saying, it seems to me, Tony, that what you're doing is you're organizing.
Frozen.
It's all right. We'll give Ross a while to come back.
Hello.
Yeah, I can.
We can hear you now.
You're back.
Sorry, Ross.
So I was just saying, because one of the things that frustrates me about the law is there's so much disorganization in terms of the way people handle the basics of anything, whether it's like managing their papers themselves or sharing their papers with the other side. And by providing a backbone on which people can go, okay, this is how we share all the documents. You can, I mean, so many disputes I'm involved in, disputes around disclosure, disputes about whether things were served on time. We shouldn't have a dispute about whether something's served on time these days, because there should be a shared folder where they put it and they, when it turned up there. So I think this is definitely the future.
Yes, well, in under the user terms for DEF, service is dealt with on the uploading of a document, because the moment something is uploaded, a notification email goes to all those users registered to that case saying, oh, something's been filed. Go log in and look. Nothing goes out with the email. You understand? It's all pure. So that's how we set it up. And if for any reason the email is said not to have arrived, then we have provisions to resolve that by reference to our database, where we keep copies of every email that's sent from the platform. So it's very simple. No arguments about, well, I posted it on, a Sunday, or entertaining though they are.
Yeah, simplicity is the key.
Yeah. Yes, absolutely. But it takes a lot. It takes a lot of work, doesn't it? You'll know this as well. Yeah. To make anything that looks simple. And to use.
Yeah. I think it's one of my big bugbears when it comes to legal tech is that complexity is the enemy. I mean, complexity is the enemy in law generally, right? Because law is too complicated. That's why it's so expensive. That's why it takes time. That's why people don't have access to justice. Is because it's too complicated. It's hard to do. It costs money. And so it's awful when you see technology has got a great idea and they come in and their idea is so complicated to operate that it just makes it worse. And it's another problem for people trying to engage in the law is they've now got to learn a new piece of tech. That has to be fought at every level, I think. Adding complexity to the legal process. It's got to make it.
I think it's got to be two things, hasn't it? It's got to meet a need. So a lot of observation must take place of what lawyers do and how they do it and how it could be made more efficient. And then if one can find something that has a need like that, it's actually then persuading lawyers and all the staff, as you say, Ross, that this is something they should do. But lawyers are not unique in not liking change, something I mentioned. They're just
talking about change, sorry, I'm just realized that this actually fits really well into our next topic. Because given the COVID-19 crisis, there's been a lot of discussion on what it means to have like a resilient and viable business model, especially given, everything that's going on in general. And I think it would help us a lot if you could share what underlying principles you think create a robust business model, especially one that can survive the winds of an economic downturn or like what we're having right now. And I think it's something that both of your business models, especially as online and as like digital technologies, will really like survive the COVID-19 crisis.
Okay, I'll have a go at that, shall I? The problem, it seems to me, is that if one is running a prep franchise in Fleet Street, we've got a big problem with the model, and everybody's out in the outer boroughs or somewhere else. It's not actually in the block that's next door where they're working. That's a problem. So if you're looking for sustainable business models in the pandemic, and hopefully we'll have that conquered in the next 6 months or so, one has to look to the way people are living, and the way people who are using this. What is the target audience? In my case, to some extent, it's the citizen. It seems to me, but it also includes lawyers. And how are they working at the moment? They're working on these phones and on their tablets and on desktops like the one I'm using now. And they're not going to the library anymore, as you said. They're using Westlaw, Ross, and LexisNexis, and so on. Long days spent in the library, much as I love them, just are a thing of the past. So to be sustainable, it seems to me, in this current climate and beyond, you have to make things easier for people, more convenient. And I always find the more people that use DEF, and it may be the same for Casedo, I'd like to hear your view about this, Ross, the more people that use it, the easier it becomes to use. And so then a bit like because it's just so easy to do that. So I'll just carry on doing that instead of wading through lever arches.
Yeah, I mean, I agree. Certainly, I agree that with the more people use Casedo, the more they use it, because they get more familiar with it, and then they realize that the benefits, build on top of each other as you get to know something, and they become more efficient with it, etc. I mean, in terms of is there a secret to having a robust business? Legal tech probably is in a good position generally at the moment in terms of the pandemic, both because law is to a certain extent counter-cyclical with the economy. When things are crashing, lawyers have just as much business as when they're booming. Certainly anyway. And also because, the one thing that this pandemic has done is unleash push aside some of the resistance to technology in the law. I think there's been a big build-up of sort of lawyers thinking we really should be more digital, we really should do more online, we really should be more efficient with these clever digital tools. But maybe tomorrow, I'm busy right now, and I think pandemics jumped in and given them. I think there was like a month back in April when no one had anything to do. When they all thought, well, I'll learn how to work remotely. And B, that just as now they've been forced to do it, there's a lot. We've moved forward like a couple of years worth in the last 6 months, at least in terms of the willingness of this industry to use digital tools. So I think from a legal tech point of view, not going to be a terrible recession for us.
I think that's right. Well, I think you're also right about the pandemic accelerating reform. And just because I realise that from what Augustine told us when we had a little meeting about this 2 weeks ago, was it, that not all members of the audience are lawyers or reading law, whether undergraduates or postgraduates. It's worth pointing out that typically law reform moves very slowly, and I'm reminded of the scene from one of the Hobbit movies, in which the hobbits are sitting on a tree, trying to encourage the trees to move more quickly to save their world. And I was also reminded of the length of time it took to get the common law fused with equity. And I was looking recently at the length of time it took from the start of that idea and until the Judicature Act was passed in 1875. It took about 75 years to get that passed. And so typically there'll be pilots, there'll be tests, there'll be outrage. Everybody will object to it. But I agree with Ross. I would say actually in the last 6 months, but now more actually, probably in the last 11 months, we've seen more law reform to come to fruition than in the past 11 years. That's my, yeah. Well, I think anybody in the audience has to realise you're not dealing with a normal, particularly with fintech. I think fintech is I would like to think that the adoption of that is driven by efficiencies. The opposite is true, I think, of legal tech.
Yes, yeah. I think that's right. I think you've got a typical tech market, and by being more efficient, we can make more money. That's not how it works for lawyers, because most of them bill by the hour. And so the reason now that they're finally embracing this tech is because they have to. And I think that's a big difference in terms of how the market reacts.
Yes. That's absolutely right.
Sorry, I realized that we've sort of covered this because we've talked about how COVID is actually speeding up the uptake of these technologies. And so now you're actually benefiting a lot from the network effects of a lot of people using your technology. The question I want to ask is that, do you think this will be a lasting change in terms of like in the future? Do you think that this is something that you'll see continue as more and more people use your product or use your platform? More people are encouraged to then use it, and it kind of has a compounding effect rather than just something that's purely an adaptation to the COVID environment.
Can't remember who went first last time. Ross, do you want to start?
Yeah, I mean, yes, absolutely is the answer to that question. I mean, we sort of touched on this, as you say. I mean, I think, if you take, for example, video conferencing, a year ago, I would have met with my clients either on a phone call or in person.
Absolutely.
I could have video conference with them. This is not new tech. I've been doing it with my family for decades, but I wouldn't have happened in the law. Now it is the default, and I think it's absolutely better than a phone call. And that will not go away. People like it. Equally, remote working. We've been able to do this for ages. It just hasn't sort of been socially, culturally acceptable within the industry. People like it. They will keep doing it. And I think e-bundles is another example. We've seen, a year ago, we began instructing to produce a bundle. The paper bundle would be the master copy. And then some people might have digital versions of that, but the paper would lead the way. In 2 months, we switched to an e-bundle dependent court system where now the e-bundle is what you're ordered to produce. And if people want to print it, they can. That's a much better way around, and it's not going to go away. Now everyone's realized they can do it. The advantages are obvious. So I think in terms of all those little steps forwards, which are, none of that's like radical technology. It's all technology's been around for a very long time. But finally, the lawyers are going, small changes to the way we do things actually are not a problem. These embracing these technologies, going more digital, being more remote and online is not a problem. And I think people have been forced to come to terms with that after years of saying, Nah, I don't think it's going to work so well for me. It's actually not as efficient as meeting in person or working with paper, which is the stuff I've heard for years now. And we all know it's not true. So.
Yeah, well, I'd echo all of that, but from a civil justice perspective, I would just add this point that what the pandemic has done is two things. It has created enormous backlogs where this country, England and Wales, never really had backlogs. It was slow, but it wasn't so slow that it was outrageous. I mean, for example, Greece, where we're in talks at the moment with the Ministry of Justice to provide the platform there, they have a backlog of cases of about 250,000 and had for a very long time. They've had to undertake to the EU that they'll do something about it. So they've introduced mandatory mediation. But that isn't the worst. If you go to Nigeria, where we're working with some of the states in that federal republic, they've got backlogs of 500,000 cases across the whole of the Federal Republic. And they've had them for years as well. So again, they've begun to introduce what they call backlog elimination programs, something that would be just, people just wouldn't think about the need for that in England and Wales. But now, I've estimated that the current state of the backlog in the civil courts is probably going to reach 500,000. But that's not in the business and property courts, nor in the Rolls building, because they have CE-file. That's the Thomson Reuters system I mentioned earlier. That was the winner of the 2014 tender. I'm talking about in the county courts, and that's small claims and also fast track. That's where the backlog is. And so that is a product of the pandemic. The effect of that is that now judges are increasingly saying, there was a case recently in the Court of Appeal, Lady Justice King, I believe, Haley, who said that the backlogs are such now in family, and this was a family arbitration case, that ADR, there must be much more ADR. Sir Geoffrey Voss, who, as some of the audience will know, is about to become Master of the Rolls, the second or third most important judge in the country, on the 21st of January 2021. He is firmly committed to more ADR, as he puts it, much greater ADR and much greater integration of ADR into the civil procedure. So that is another effect of the pandemic, which means I expect to be increasingly busy over the coming years. Hurrah.
Tony, do you see it as sort of what might happen is that effectively in the civil courts, it will be a case of, well, if you want your dispute decided soon, you've kind of got to go private. You've got to go into some ADR mechanism that the parties will pay, even if that ends up in arbitration with a binding decision from an independent arbiter. That people are going to be increasingly choosing these routes because it's the only way to get a decision. Like the same way, you need a hip replacement, you can wait 6-8 months, or you can go private and get it done quickly. We'll see the same thing in the court system.
Sorry.
No, and my follow-up would be: do you see a risk of a 2-tier system there developing in terms of quality as well?
I take the analogy is very good as to the world of hospital treatment. Whether it becomes 2-tier, I don't know. I'll come back to that if I may. I do think that citizens are going to be required to go through some kind of ADR. Recent feedback from the small claims opt-out scheme showed very limited take-up of that, and that's being looked at the moment. Very limited take-up, surprisingly, because at that level, people are deeply invested in their claim. In the small claims track, they're not represented by lawyers who typically wouldn't want to encourage that ADR anyway, but nevertheless, lawyers are often seen as the gatekeepers for ADR. I draw a comparison with a recent innovation in the world of possession cases, where something called review days have been introduced to deal with the tsunami of possession cases that was anticipated once they resumed those hearings. And what happens on a review day, so the reactivation notice, as it's called, for the stayed possession case served, and then the court had filed, and then the court list 28 days later a review day. And at the review day, if the case hasn't been settled between landlord and tenant, at that point, there is to be negotiation between the parties' solicitors. That'll be the landlord solicitor and the duty solicitor, housing possession court duty solicitor, paid for by the state, by a legal aid. And if that doesn't work, they have to go to mediation. And the judiciary dealing with possession cases has been given a steer by the higher-ups that it will be in order to strike out any claim that has not gone through ADR. And that means you could start again, I suppose, question about second bite of the cherry and all that, but that means you have to start again, which means you go back to the other end of the queue, and you have now hearing dates being given for 22, I understand. So it's, I don't know, just to come on to the second tier justice thing, I think it's not necessarily second tier in terms of, like, if you mean first class ticket on the train and second class ticket, or standard class as they call that. I don't see it like that. I think it's a choice that the citizen has. Do I want a binary decision? Is that important to me? Or do I want to bring the parties together? Do I want my opponent to come together with me to sort something out? And if I'm suing for £25,000 in the fast track, then probably I want my money now. And so I would welcome the opportunity to bring the parties together. In my experience as a recovering commercial litigation solicitor, I always tried to coerce a situation where the parties came together for a conversation. It didn't always work, but I found it did usually. Closer to the hearing date, the more people's minds were focused on the risks.
Sorry, if I may interrupt, I wanted to ask, because we wanted to ask you guys both, where do you see the future of the legal industry headed? And in discussions with our own team, we asked whether, do you think there will be a proliferation of litigious claims because of the reduced cost and hassle of litigation under ADR, for Tony especially? And in general, as an addendum to that, where do you see like the future of the legal industry headed?
Ross, do you want to take the future of the legal industry and I'll do the ADR piece?
Yeah, sure. Up to you.
Oh, right. Okay. Well, the ADR piece then. I think one has to understand, thank you for the very interesting question, Augustine. I think one has to understand the starting point is civil claims. And I said, DEF has written a white paper on this on our website in the newsroom, that there will be, I think I've demonstrated, there will be a backlog that exists now. I think it's widely recognised both judicially in decisions such as Haley and elsewhere. And when you get down to the ground, you see the kind of adjournments that are being adjourned dates that are coming through now for back end of 21 and beyond 22 often. And I think that we've also shown in that white paper there will be a tsunami of different types of claim coming out of the pandemic of one kind or another. There's already a shortfall on issued claims compared with 2019. Over the last 6 months, the number of issued claims is 500. Well, actually, it's 650,000 claims down. So I discount that down to 500,000, which is still a lot, to take account of the fact that either or both parties may be bankrupt or insolvent in some way. Thus, you're not going to get the full 650 back. But I think you'll get more than that. So I think, as Ross has pointed out, as a result of people recognising the courts are backlogged and it'll take forever, we'll never get anywhere. Great, it's a kind of great opportunity for debtors, for example, to just put things off endlessly. Better to get into a situation where we have some kind of ADR or a facilitated negotiated settlement going on to try and resolve matters quicker. So I think you will see a huge increase in ADR, particularly once Geoffrey Voss gets into position as chair of the CPRC, Civil Procedure Rules Committee. And of course, he also occupies the role of chair of the Civil Justice Council. And just on a final point, if I may, in that connection, there is a consultation out from the Civil Justice Council about terms of reference for a consultation. So it's a consultation about a consultation. Consultation about the terms of reference for a coming consultation about pre-action protocols. and whether ADR should be mandatory, or as it's put, I think, de facto mandatory, whatever that might mean. And it's the first time I've ever seen the terms of reference of such a consultation out to consultation. So I think it's a question of raising the profile of the issue and bringing people together to recognise this is coming.
But it's not, I mean, to pick up on Augustine's question, it's not going to be the case that the surge in ADR is led by a reduction in cost, is it? And I think, it's the interesting thing about the legal, you reduce the cost of litigation, it doesn't really make it that much more attractive. It's still costly, it's still high risk. Unless you disagree, would you say like people go, oh, ADR used to be expensive, but it's got cheaper, we'll now consider it? It's always been cheaper than litigation.
Yeah, yes, it has always been cheaper than litigation because it potentially holds out the opportunity of stopping the litigation, and in commercial context or any context, rebuilding a what must be a broken relationship of some kind, commercial, personal, whatever. And so it seems me to offer a much better solution than the civil litigation. It's quicker. It will also be cheaper. And if it's managed online, then it's faster as well.
But do you? I mean, I suppose what I was going at, do you see that being driven by the market forces of the parties to the litigation itself choosing ADR because it's cheaper, or because the system, at the regulatory level is going, the combative system is not sustainable. We need more of this, and ADR is being imposed on the users rather than being chosen by them because of efficiency.
Yeah. In small claims and fast track, I see exactly that. It is both, actually. It is the higher ups deciding that we can't cope with the number, because in the county court, as the Lord Chief keeps pointing out, there's no CE file there. There's nothing there. It's just the paper. And yesterday's spending review made it clear that the county court is not going to be getting any e-filing system anytime soon. There's no money for that. No money for that being made available. So it is the fact that it's a nightmare at that level, not at the higher level, as it were, the multi-track, which is in the BPC and the business and property courts, forgive me, and also the roles building jurisdictions, which I think is pretty much the same thing, really, isn't it? But that's only accounting. Those courts only account for 30,000 of the 1.2 million cases issued every year in England and Wales. And those 30,000, a lot of those are basically petitions for bankruptcy or winding up issued by HMRC. So at the small claims and fast track level, it will be the driving it will be the requirement to undertake ADR, and people realizing increasingly that it's just what do they want? They want a solution. That's all. What they want. So it is a solution. It may not be a binary solution like, oh yeah, I won, but actually you do have to realize, and this exhortation is already starting. So to go back to the possession cases, if you look at the guidance on review days and possession cases issued by the Ministry for Housing, Local Government and Communities, it starts at the top with avoid court, no exclamation mark, but avoid court. So there's a message.
I spend a lot of time trying to keep my clients out of the court. So I've got to now answer grand questions about the future of the legal industry. Which have been that way. Where is the legal industry going in terms of technology and otherwise? I think there's sort of two things that get talked about a lot generally, and they're kind of on opposite ends of the spectrum. On the one end, sort of the big law end, there's AI, and is that going to steal our jobs? And what efficiency is that going to bring? And are lawyers going to be made as redundant as drivers will be eventually? And all of that. Are we going there? I think it's some way off at the moment. I don't think the legal industry is organised well enough to embrace that kind of tech at the moment, and I think it's far too resistant to change. I think what the first signs of that kind of thing will be, the very sort of wide pyramid structures of big law firms where they have a lot of trainees and junior associates to do sort of the grunt analysis work. Will maybe those pyramids will gets steeper as they take on less people at the bottom end, because they've got, essentially what is glorified search is what legal tech AI looks like at the moment. Very clever search algorithms that can pull out, you say I've got 10 million documents and I need to find every IP clause. There is. So, and we're seeing some of that tech coming on. I mean, so that's what AI is starting to look like. And query again, is it killing jobs, or is it just meaning that people do more with their time? So there's that, and I think that is exciting. And there's blockchain also in that big law space, which again is just going to hopefully make lawyers better rather than replace them. Where I think actually more of the action is going to be in terms of legal industry and technology at the moment is at the other end, at the access to justice end, and the low value claims, the type of stuff Tony's dealing with, where, I mean, you've seen we've had the digital court has been trialed for a couple of years now, the entirely digital court system, where they've been dealing with mostly lower value claims, and there is no courtroom. There is just papers submitted online, judges reviewing them, decisions being made entirely within a digital portal. So there's no hearings, it's all on the papers, but you're still getting a judicial decision. And that sort of stuff is, I think, going to be where the legal industry, in terms of litigation at least, goes first with legal tech. And it's going to be, and that's where you get into all those problems of, well, are the systems simple enough and easy to use enough so that the people, can use them directly? Because the whole point of the e-court is that you don't need a lawyer. You just go log into their portal, and you can get you can put your arguments down, and you'll be guided through a process, sort of even cheaper than in the small claims court and things like that. So I think there's a big move there that's actually going to be more impactful in terms of most people's interaction with the legal system than the sort of very fancy technology that the corporate lawyers get excited about. But they're both going to happen in independently of each other. In the middle will remain the lawyer who's got to figure out what his client wants, figure out whether it's worth his client fighting for it, and put his shoulder into that problem. So that's what I think it looks like. I don't know.
I think what I'd just add about the AI piece is that I echo everything that Ross has said. I think that it is early days for blockchain, which is very sexy to talk about. There are plenty of use cases made for blockchain, but not much use made of it outside currency, Bitcoin and so on. But also global freight shipping has if you get a chance, have a look at something called TradeLens, which is a really interesting use, connecting containers with shippers of containers. And that's really interesting. But with the AI piece, you need big data, lots and lots of data. And it's just in the law. I mean, we are spending some time looking at the platform generates data in a rather crude way at the moment. I want to take it much further. But the availability of data within the law is diffuse, very diffuse. It's in particular files. I've been doing some work with Lucy Greenwood on the Greener Arbitration Steering Committee, and we've been trying to get some data for how law firms undertaking international arbitration, can they save carbon emissions? So we need to know, in other words, how many train journeys, how many couriers are used per case of different types, how many flights are taken. Well, the pandemic has dealt with that, hasn't it? And so on. But to get that data out of law firms it's proved to be quite difficult. We've got some data, but it's not. We need much more, and it's very difficult because it's not that accessible, and everybody's working on the next case.
Yeah. I mean, I think that there's that. Some people are imagine at some point, there's an algorithm, for example, someone's event that can predict with apparently 80% success rate whether your case will win or lose in a personal injury scenario, and stuff. Whether the extent to which stuff like that will be deployed to convince people to settle and pay up will be interesting. I mean, I think we'll probably find more often than not people will reject those decisions because they don't like. And it ties into that. If you start having a piece of an algorithm deciding your case for you, can you decide whether it's appealable? To what extent can those algorithms take into account changes in policy, the policy behind laws that the senior judges do in their own obtuse way? They evolve the law continuously through the application of policy considerations. And there's going to be a very, the technology that says, oh, we can predict what the outcome of this will be. We can predict where the problems are. Will it be able to take account of those sort of more cultural aspects, and will it be able to, by doing so, build enough trust in its users to be given responsibility? And I suspect for some time to come, people will not trust the outcome of legal tech unless it's verified and backed up by people. But
yeah, I was just going to add to that. There's a debate at the moment about algorithms predicting the future, and to do that they need data, and to do that they need to be able to what is called scrape, which I understand is gather data from decisions. And so there has been some discussion, I believe, debate about whether such algorithms will be allowed to scrape data from the judgments held on Bailey, the repository of judgments, and that's been refused up to now. In the States, they can scrape data from head notes of judgments, but not here. So that's another big issue before you can even get into working out whether these algorithms actually work or not. And until that's overcome, it's going to be very slow work. And to be honest with you, if people's adoption of platforms like mine and others is left to lawyers' own devices, it will be quite a long time before any of that actually takes place. Because, as we said, I think at the top of this conversation, unless lawyers are made to do things, they will not do them. For example, there was an electronic bill introduced, which I had some input in a committee developing the new bill of costs, NBOC as it was called, a Rupert Jackson idea, and that was introduced into the Senior Court's Cost Office on a voluntary basis for a year. Only 2 firms actually put any bills, or 2 bills, I would say, through that process, and then it became mandatory. And now, of course, everybody's doing it. It makes life a lot easier. That's just one example.
Yeah. Thank you guys for sharing. It's actually quite interesting to hear about what the actual future of law would look like and what are some of the challenges in adopting these technologies. And I think you're right in saying that a lot of people won't trust these technologies until they are sure that the humans behind the computer at some point looking at it. I wanted to ask an additional question, which kind of changes tack from what we've been discussing so far, which is that what advice do you guys have for students who are conflicted between choosing to start a career in a corporate law or in a startup or in even starting their own business like yourselves? And what advice would you give them?
Well, if I have a go at that first, I would strongly recommend, it's not of universal application, but get some experience under your belt first, say for 3, 4, 5 years, perhaps. Develop your networks, your contacts, and gain experience. Experience is vital. And then branch out. I would always recommend, I would say that obviously, given my history as a serial entrepreneur, excuse me, I would recommend everybody always be an owner, always develop your own ideas. Ideas are the lifeblood of the lawyer, whether that's entrepreneurial or interpretations of cases. So I'd encourage you to start your own business. But before doing so, get experience, develop your contacts, but also observe, something I mentioned at the top of this, observe, spend time observing where the opportunities lie, because if you don't observe carefully, you may make the wrong move and then be back to square one.
Yeah, I mean, I would echo that. I think that, as someone coming out of university, obviously do something you want to do, because I think if you're having the energy behind you because you enjoy what you're doing, is priceless. Be prepared to continue learning forever. because the world is very dynamic and there are opportunities everywhere, and people are cross-pollinating from industry into industry all the time. So be prepared to learn and keep learning, and be prepared for change too, and embrace change. I think don't feel you're going to be stuck in something. If you're prepared to learn, you can change course at any point. I mean, if you don't know what you want to do with yourself, law is a great sort of thing to get in your pocket. Qualifies law, just simply understanding the basics of your rights, and how the law operates. It is a life skill that can be employed. I mean, certainly, obviously, in any kind of tech, any kind of business. Understanding the basic principles of law is going to add to your value as an employee a lot. So if you don't know what to do law, and then figure it out later. But if you want to if you love coding, code too, because equally, again, very translatable skills, very high in demand as well. You can easily learn to code, and then that will allow you to transition into some other area. You go into law after that. No understanding about IT, go into some other part of the IT world or the financial world. So I would say both tech, developments and law are the kind of sort of core key skills that can be deployed everywhere. So be bold.
Yeah, I just add a thought that both Ross and I have spoken from time to time during this conversation about the unwillingness of lawyers to change, the resistance to online and so on. I should say that both my company and Ross's have worked with undergraduates. In my case, it was last December, we supported an environmental law moot at King's College, London. Perhaps I shouldn't mention that institution in this context, but anyway, I have. And there was absolutely there was a great enthusiasm and embrace, if you like, for DEF. When I went down to do a demo to help the undergraduates understand the platform, it was a demo in which I had to do nothing. They already understood it. They'd always worked through it. It was very intuitive, very simple. That's great. What else does it do? I said, well, it does quite a great deal else, but you're not going to get to play with that. But it was so refreshing. So I am very optimistic for the future of both Casedo and DEF, given the kind of undergraduates I've engaged with.
Yeah.
Nice. I want to ask if, in particular, if there are any standout or identifiable qualities that you think make a good entrepreneur or a good business partner that you would like to see more from the upcoming generation of law students.
Be stubborn.
Being able to communicate in enthusiasm, I think, is very important in anything entrepreneurial. Being able to communicate your enthusiasm, and infectiously if possible. I think often underestimated in terms of it's a soft skill, but very important.
Yeah, I'd just add to all of that expect to fail and expect to lose opportunities and expect to grow from those failures, provided you learn from the failures. I will tell a story about one contract that I thought I had signed and was told everything was going to commence in January of this year. Yippee! And went to demonstrate to the people on the ground, only to discover that matters had not been communicated perhaps as they ought to have been to staff. And furthermore, they believed that DEF could bring nothing to them in terms of efficiency. They couldn't understand how DEF could make things more efficient for them. I have that email. I won't name names, but I have that email framed on my office wall. I'm not going to show you today, but that was a failure. But it taught me a great deal about the nature of the business that DEF serves, and the fact that what we are providing is a tool for mass ADR.
Yeah, exactly. I absolutely agree with all of that. I mean, the most important thing to us as a business is listening to the people who complain about our product.
Yes.
And that's the feedback we value most. Is occasionally we get someone who says, "Look, these are the 10 things that really annoy me about Casedo,"
Right.
and we hopefully can say to them as we, "Don't worry, we're working on them." But if we're not working on them, we get to work on them, because that's how you improve both your product, but also, you know, the same applies to you as an individual. If someone rejects you for a job or a place somewhere and an opportunity, you've got to think about why and apply that same rationale to your career and your life.
I would like to add that for anyone who is more interested in finding out about more of these products, especially for Casedo, do feel free to come join our Legal Tech conference on the 30th of November, where Casedo will be holding a demo on how the product works, and you actually can get your hands on the Casedo product itself. And I believe that Casedo is actually running a competition during that where you stand a chance to win £50 if you think of an innovative use of Casedo that's outside the law. So please do come and attend and join those events. Now, thank you guys both for coming down today. Is there any last things you would like to say, or last things you would like to tell our young audience today before we head off?
I'd just add to what I've said, that you should think bold, be bold, and when you're knocked back, as you will be knocked back, get back up again.
Yeah, good. Run with your ideas. Run with them, because, you know, if they're good, they'll live out. Yeah.
Thank you very much for inviting me, and it's been fun to do this with you.
Yeah, thanks, Augustine.
Thanks, guys. I'll end the broadcast now.
Okay.